दोस्तों नमस्कार। आज फिर से आपके सामने एक ऐसा टॉपिक लेकर के हाजिर हूं जो आपको शायद पसंद होगा। अगर आपको पसंद भी नहीं है तो ये राष्ट्रीय राजनीति के ऊपर बहुत बड़ा प्रभाव डालने वाला है। जैसा कि आपको मालूम है कि मार्च के महीने में सूरत के मजिस्ट्रेट कोर्ट ने राहुल गांधी को अवमानना के आरोप में 2 साल की सजा दे दी थी और उसके बाद उनकी संसद सदस्यता चली गई थी। उन्हें अपना घर खाली करने का भी आदेश दे दिया गया था। इस मजिस्ट्रेट के ऑर्डर के खिलाफ राहुल गांधी जी ने सूरत के सेशन कोर्ट में अपील की थी और वहां पर उन्होंने अपने कन्विक्शन के ऊपर स्टे करने का प्रार्थना की थी। आज सूरत के सेशन कोर्ट का आदेश आ चुका है और सूरत के सेशन कोर्ट ने राहुल गांधी के कन्विक्शन के ऊपर स्टे लगाने से मना कर दिया है। मेरा वीडियो बनाने का मकसद यही था कि जैसा मैं पहले करता हूं कि आपके सामने मैं कोर्ट के ऑर्डर को प्रस्तुत करके उसको एनालाइज करूं। तो देखते हैं कि कोर्ट का ऑर्डर क्या बोलता है। मैं इसको आपके सामने शेयर करता हूं। देखिए कोर्ट का ऑर्डर क्या बोलता है। आपकी स्क्रीन पर यह सूरत कोर्ट का ऑर्डर आ गया है। ये 27 पेज का ऑर्डर है। इसमें लिखा है, इन द कोर्ट ऑफ 8th एडिशनल सेशन जज एट सूरत, क्रिमिनल अपील नंबर 254 ऑफ 2023। अप्लेंट कौन है? मिस्टर राहुल गांधी वर्सेस रिस्पोंडेंट पूर्णेश मोदी एंड अनदर। ये ऑर्डर है। ऑर्डर बिलो एग्जिबिट 5। Present application is preferred by the appellant, original accused Mr. Gandhi, under section 389 and 389(1) of Code of Criminal Procedure 1973 for staying the conviction imposed by the judgment and order dated 23/3/2023 by the learned Chief Judicial Magistrate Surat in criminal case number so and so. इसमें राहुल गांधी के एडवोकेट, सीनियर एडवोकेट आर.एस. चीमा थे और उनके जो एडवोकेट थे केसी पानवाला थे और हर्षित तोलिया, केतन रेशम वाला, ये पूर्णेश मोदी की तरफ से अपीयर हुए थे और नयन सुखड़वाला अपीयर फॉर द रेस्पोंडेंट स्टेट। The advocate appearing for the parties are heard at length. I have thoroughly perused the application along with memo of appeal reply filed by the respondent, White Exhibit 8, and papers produced on record by both the parties. Learned advocate for the parties have relied upon the following pronouncement of Honorable Court, Apex Court and Honorable Gujarat High Court with regard to the settled legal position. ये पहला केस है जो लॉ के स्टूडेंट हैं उनके लिए बहुत इंपॉर्टेंट है, इसको नोट कर लें। राम नारंग वर्सेस रमेश नारंग। मैं इसको पढ़ता नहीं हूँ, सब रेफर कर रहे हैं। दूसरा केस है केशी सरीन वर्सेस सीबीआई। तीसरा केस है नवजोत सिंह सिद्धू वर्सेस स्टेट ऑफ पंजाब एंड अदर। चौथा केस है Ravikantas Patil versus Sarvamias Bengali. पांचवा केस है स्टेट ऑफ महाराष्ट्र थ्रू सीबीआई वर्सेस बालकृष्ण दत्तात्रेय कुमार 2012 का केस है। श्याम नारायण पांडे वर्सेस स्टेट ऑफ यूपी, ये भी सुप्रीम कोर्ट का केस है। छठा केस। सातवां, लोक प्रहरी थ्रू इट जनरल सेक्रेटरी एस.एन. शुक्ला वर्सेस इलेक्शन कमीशन 2018 का सुप्रीम कोर्ट केस है। स्टेट ऑफ गुजरात वर्सेस दादाभाई नानाभाई बराड, ये गुजरात हाईकोर्ट का केस है। अब इसके बाद क्या कोर्ट क्या बोलता है? पैरा 5 में, बेस्ड ऑन द above provision of the following tests are required to be established and satisfied by the appellant. There should be a rare and exceptional case for grant of stay against conviction. There should be a special and compelling circumstances justifying the grant of stay against conviction. There should be irreversible consequences leading to injustice and irreparable damages in the event of non-granting of stay against conviction. There should be no criminal incident barring the conviction in question. There should be prima facie case in merit. Learned Chima, by relying on the judgment of Sam, has submitted that the court would be reluctant in granting stay of conviction when appellant fails to show any exceptional circumstances if the sentence is of death, of life imprisonment, or of a period not less than 10 years, and there is no irreparable injury or loss. It is further submitted that in the case in hand, all the above factors are successfully demonstrated by appellant and hence prayed to allow this application. In view of the above, this court is required to see that whether learned trial court committed a grave error in considering the evidence against appellant and thereby imposing the sentence. It is also required to be looked into whether the court at this stage can evaluate the evidence by discussing the merit of the case. अब ये ऑनरेबल सुप्रीम कोर्ट की बात कर रहे हैं नवजोत सिंह सिद्धू में, though for the purpose of decision of the prayer made by the appellant for staying or suspending the order of conviction, it is not necessary to minutely examine the merit of the case. Nevertheless, we consider it proper to refer to the medical evidence which has an important bearing on the nature of the offence alleged to have been committed by the appellant. गुजरात हाई कोर्ट क्या बोल रहा है दादाभाई बराड में, that while dealing with the matter of the admission stage, even recording of concise reason dealing with the merit of the contention raised before this court may suffice. Keeping in mind the above, I proceed to discuss as under. The learned senior Chima has raised objection with regard to maintainability of the complaint filed before learned court. It is the case of prosecution that appellant during election complaint on 13/4 at this address a gathering at Kunnar, a village at a distance of about 100 km from Bangalore in Karnataka. In his speech, he alleged that the Honorable Prime Minister Sri Narendra Modi had and further alleged that why all thieves are having surname of Modi. Learned advocate P. Chima drew attention of the court to section 119(1) of CRPC and submitted that the complaint cannot be termed as aggrieved person and hence are not authorized to file the complaint. It is further stated that the expression Modi propounded by the complainant do not fall in category of association or collection of person as stipulated in explanation 2 of section 199 of IPC. It is submitted that the learned trial court has failed to appreciate the important issue of binding precedents in this regard. It is further submitted that as per the complaint assertion, due to the defamatory speech by appellant, insult and humiliation has been caused to 13 crore people of Modi government. It is submitted that the association and collection of persons cannot embrace a large population of this, which is not a definite or indefinite group. The learned senior advocate, by drawing attention towards evidence of complainant Purans Modi, Niranjan Bhai Rathod, and Manohar Lal submitted that the complainant and witnesses have made admission with regard to Modi community. It includes various surnames like Rathod, Teli, Modi, and others, which demolishes the case of prosecution. It is submitted that from the evidence of above, it is the concept of Mr. Modi being an association, a person being entirely unacceptable. It is submitted that the complaint was filed with political motive. Learned senior advocate for Chima had relied upon following pronouncement. G. Narasimha versus TV Chokappa Subramanian Swamy versus Union of India. S. Khushbu versus Kannamalai 2010. Narottam Das Elsa versus Patel Magan Bhai. Pradeep Mavdhani, editor of Naubat Daily and other state of Gujarat. K. M. Matthew versus T.S. TV Balan. Aruna Selvi versus Purn Narayan Sinha, 1983. Shashi Kumar Ismail versus Vijayan. MP Narayan Pillai versus MP Chako Vishwanath Sambhunath. P. Karunapuran versus Shri C. Jayasuriyanan. I have gone through all the above reported pronouncement, whether it is it is held that a collection of persons must be identifiable bodies, so that it is possible to say that with definiteness that a group of particular person as distinguished from the rest of the person is not established so as to be relatable to defamatory word or imputation. The complainant is not mentally ill. That there cannot be defamation against a community as such. Community as such may not have a reputation, but the reputation will only be of individual. When the defamatory matter affects each and every member of an uncertainable class or group, each of them or all of them could set the law in motion, as against which the learned advocate Mr. Harshit Tolia has stated that learned trial court has appropriately dealt with this issue by arguing that A. There are several persons having surname Modi in India. B. The accused has compared the person known by Modi surname with thieves and thereby has defamed the well-defined class of the society, which include the complainant. C. After attributing defamatory statement against Honorable Prime Minister Narendra Modi, the accused did not stop there and further commented that while all thieves have the common name surname of Modi, it is submitted that the defamatory speech was made by the accused and he had the knowledge that he could harm the reputation of Modi's surname holder, and such statements were made only with a view to earn political gain. I am mindful of this at this stage. If I deal with above issue in detail, then it would cause prejudice to the parties at the time of final hearing of appeal. However, looking at prima facie evidence and observation made by learned trial court in para 19.2 in imputed judgment, it transpired that the appellant had made certain derogatory remarks against the Honorable Prime Minister Narendra Modi in general public and further compared the persons having Modi's surname with thieves, and the complainant is also having surname of Modi. Moreover, the complainant is ex-minister and the complainant is ex-minister and involved in public life, and such defamatory remark would have certainly harmed his reputation and caused him pain and agony in society. For such reason, I do not agree with the objection raised by Ms. Chima, learned senior advocate, with regard to unmentability of the complaint. 9. Learned senior advocate Mr. Chima has further submitted that the learned trial court erred in observing that the alleged speech of complaint was being proved. It is submitted that the complaint was filed based on a newspaper cutting received on WhatsApp by the complainant, and such newspaper is never produced before the learned trial court. It is submitted that though there is presumption of genuineness envisaged in Section 81 of the Evidence Act, the complainant failed to produce and prove the same. Moreover, the pen drive, Exhibit 21, CDs, Exhibit 26, and DVD are never proved before learned trial court. Then also, by accepting such evidence against appellant, the learned trial court has committed grave error. It is submitted that alleged speech is not being proved either by oral, documentary, or electronic evidence. The detailed grounds are narrated by the learned advocate for appellant from page 37 to 54 in appeal memo. In, in this regard, it would be relevant to note that upon going through the record, prima facie, it revealed that the evidence of Mr. Ganesh Bhai Manjunath Yazi, exhibit 67, that he was present on 13/4 in public gathering, which was addressed by the appellant at Kolar, and he had categorically stated that In his statements about the defamation speech being given first against Honorable Prime Minister and thereafter against all the person having Modi surname. As per the submission of London Advocate Zatolia, during the deposition of witness Yaji, he was shown the video of the speech and the CD was produced only to corroborate the version of witness and the CD was not required to be proved. It transpired at this juncture that Renner trial court has rightly relied upon evidence of Sajaji as an eyewitness, and I believe that the discussion of admissibility and mode of proof of electronic evidence would be required to be made at the time of final hearing of the appeal. Moreover, the evidence of complainant and witnesses like Niranjan Bhai Rathod and Manohar Lal is examined by me only for the purpose of deciding this application. Learned senior advocate Mr. Chima has shown his dissatisfaction over the applicant did not get the fair trial since inception of case and about lack of jurisdiction. It is submitted on behalf of applicant that the applicant was resident of Netherlands and London trial court had no territorial jurisdiction to accept the complaint and issue summons without holding preliminary inquiry. It is submitted that there is violation of section 202 of CRPC as it provides mandatory requirement before issuing summons. It is further submitted that the complainant is strange. In strange manner, rushed the Honorable High Court and obtained a stay thereafter. Suddenly withdrew his application, stating that there was sufficient evidence against the applicant, which was caused grave apprehension on the issue of fairness of the trial. It is submitted that the incident occurred on 13/4/2019, which was reported on 14. The complainant advised for verification recorded on this. That till summoning, no evidences were produced by the complainant. It is submitted that London trial court has also committed an error by relying upon the FS of appellant as the same cannot be relied upon because the purpose of FS is to seek explanation of appellant for the evidence brought on record, whereas the electronic evidences were not a part of FS. It is submitted that London trial court has shown undue harshness in imposing the maximum sentence of 2 years. It is submitted that no reason was given by trial court for inflicting maximum sentence and not granting benefit of probation. Learned Advocate Mr. Tolia has submitted that Honorable Supreme Court has directed all the learned of MPs, MLA, hence the learned trial court did not do anything wrong in conducting the trial viciously. It is further to be said that appellant had never challenged the order of dispense of process and the ground of lack of jurisdiction cannot be agitated as the stated and trial could not be stated to be vitiated. Of Honorable Apex Court. It further appeared that the verification of complaint was recorded on 16/4/2019 and thereafter on 2/4/2019 after going through the complaint, verifying the facts and after hearing the learned advocate for the complainant upon primary satisfaction, the summons was issued. At this stage, it will be previewed to refer the following judgment. ये सुप्रीम कोर्ट का सुनील तोडी वर्सेस स्टेट ऑफ गुजरात है. Then SS System Private Limited versus Kimberly Clark Hygiene Private Product Private Limited 2001 महाराष्ट्र का है. बी. मैं जजमेंट के अंदर का पार्ट नहीं पढ़ रहा हूँ. जब आपको जरूरत होगी तो आप इस जजमेंट को आप मेरे से मांग सकते हैं या आप इसको डाउनलोड करके पढ़ सकते हैं. Based on the above discussion and relying upon the above position, apply to transpire that the learned magistrate has, after giving thoughtful consideration, had issued the summons. Cannot be accepted at this stage. So far as the imposing of maximum punishment is concerned, very important. It would be worthwhile to observe that the appellant was not an ordinary person and was is given by appellant on 13/4/2000 was during election campaign. Moreover, high standard of morality is expected from a person like appellant, and the trial court had inflicted sentence which was permissible in law. Further, it appeared from the record that all opportunities were accorded to appellant for cross-examining the witnesses. Hence, I do not agree with the contention of learned senior about appellant then it would cause him irreparable damage. The above question can be answered keeping in mind the legal in earlier parties. Chima has raised various objections with regard to manner in which trial proceeded and the reasons cited by the learned when convicting the appellant. Such objections are appropriately dealt with by this court, and upon going through the evidence of the crime, it is found that the judgment imputed is well the appellant had a strong crime case and appeal is most likely to succeed in view of the ground raised by the appellant. It is submitted that Honorable Supreme Court in Syam Narayan held that the cases where the sentence of death or life imprisonment or imprisonment less than that we held valid criteria for determining whether sufficient ground exists in no exercise into exercise the jurisdiction in favor of appellant. It is further submitted that the case against the appellant neither falls under the Prevention of Corruption Act nor it is a case involving moral turpitude, hence paid for relief to grant the relief in favor of E. It is submitted that appellant was able to suffer disqualification Parliament constituency in Kerala. It is submitted that the said constituency with a record margin of 4,31,770 votes duly noticed in very judgment that the act of sitting side of election has the effect of overriding the choice of the aspiration, that it is also recorded in various judgments that the consequent act of holding a by-election entail a burden on the public. Based on the above submission, it is that the appellant would suffer an irreparable loss if an order of suspension of is not passed and the injury suffered by him would be. And a senior advocate for appellant has submitted that out of 12 offences mentioned in reply, Exhibit 8 against the appellant before the different courts of India, in one offence registered at CGM Division Patna, Sadar, criminal case number so and so, no process has been issued. In offence number CGM Haridwar, bearing so and so, the appellant has not received any summon. The offence registered at CGM Ranchi, bearing so and so, and CGM Court Patna's other bearing so and so are with respect to same speech, based on which it is submitted that the wider spectrum is required to be seen. The learned senior advocate Mr. Sima, in support of this submission, has relied upon following pronounced Indra Kapoor, Mohammad Mukin, Sayyid Muhammad Nural, Amir, and other Sakuntala Khatik, Sheila Kuswaha, Prahlad Lodhi, Nehru, Siwal Karbai. Relying upon the above pronouncement, the learned senior advocate Mr. Chima has submitted that various high court have considered the circumstances of depriving candidate from conducting election of LMP would fail in the category of exceptional case, and such circumstances can be termed as irreparable and irreparable loss, as against which learned advocate Matolia has relied upon judgment of Honorable Appellate Court in Jyoti Basu versus Devi Ghoshal, 1982, wherein the Honorable Court, a right to elect fundamental, though it is to be democracy, is enormously enough, neither a fundamental right nor a common right. It is pure and simple instituted, so the right to be elected, so the right to dispute an election. Learned Council, Learned Advocate Ms. Tolia have every relied upon the judgment of Honorable High Court in case of Naran Bhai Bhika Bhai Kachadia versus this in 2017, Gujarat High Court. It is submitted the above order passed in Naran Bhai was challenged before the Honorable Supreme Court by way of criminal appeal number so and so, and considering fact was acquitted of more serious offence under the scheduled caste and scheduled caste, and as compromise entered between the parties and unconditional offer of compensation by the appellant to the victim and unqualified terms of condition by the appellant of submitting a bond of good behavior, the Honorable Court allowed the appeal. It is further submitted that Honorable Apex Court, while allowing appeal, had not disturbed or quashed the finding of Honorable Gujarat High Court, but the appeal was allowed based on the evidence. Letter Advocate Mr. Tolia has also read the judgment of Honorable Apex Court in case of Kanka Rekha Naik versus Manoj Kumar Pradhan. Tolia has further submitted that the plaintiff has miserably failed to show that the judgment of the trial court is so perverse, due to which exceptional case is made out in his favor. It is further submitted that when a person like a plaintiff commit an offense in his public life, then it will have more gravity than the offense committed in personal life. It is also submitted that although learned counsel of the plaintiff has stated that appellant won with record margin from this. However, the appellant had also lost his seat from Amethi constituency. Therefore, winning with record margin would not create any special circumstances in favor of appellant. It is further submitted by Mr. Tolia that the appellant in the capacity of member of parliament, the second largest political party of the country, committed the offence by delivering defamatory speech in which news public gathering during the general election estimated that either MLA or MP or any elected representative are at par with any other ordinary citizen and cannot claim any special privilege. On the contrary, the public representative like appellant is expected to and need to be more careful and for any action or inaction. It is submitted that the right of suspension corners of the statute only. It is also submitted that the right to appeal lie for the suspension of conviction pending appeal does not have a force of mandate but is merely a statutory for the decision right present in with the court. It is submitted that the accused therefore cannot claim the right of suspension or conviction as a right of enforceability. It is lastly submitted that there are 12 offences of similar nature registered and pending against the appellant, based on which it is submitted that the appellant is in the habit of making such defamatory and responsible statement. It is not disputed fact that the appellant was the member of parliament and president of the second largest political party, and looking to such situation of appellant, he would have been more careful with his word, which would have large impact on the mind of people. Any defamatory word coming from the mouth of appellant are sufficient enough to cause mental agony to aggrieved person. In this case, by uttering defamatory words, like comparing person having surname Modi with views would definitely have caused mental agony and harm the reputation of complainant who is socially active and dealing in. Moreover, considering the juxtaposition of law with regard to considering criteria of best qualification as enumerated in section 8.3 of Representation of People, I hold based on the above discussion, the removal and removal cannot be termed as reversible or loss or damage to the as a message in arbitral question on this. The learned advocate Chima has also submitted to consider the criteria and broad feature of Nojo Shishuddhu. It would be relevant to note that the said case, individual was not correlated with the public life of. Moreover, in that case, the Honorable Supreme Court has appreciated that the appellant has chosen to adopt a moral path and had set high standard in public life by resigning from his seat, whereas in present case, the facts are totally different and hence the said judgment could not be helpful to the appellant. Based on the above discussion, I hold the learned counsel for the appellant has failed in demonstrating that by not staying the conviction and denying an opportunity to counsel the election of account of disqualification under section 8.3 of Organization of Death, and irreversible and irrevocable damage is likely to be caused to the appellant. The Honorable Supreme Court has held in numbers of pronouncements that powers that under those to suspend stay is required to be exercised with caution and this. And if such power exercised in a casual and mechanical manner, the same would have serious impact on the public perception, on the justicial systems, and such order that the appellant has not made out any such case to suspend the conviction recorded against him. I pass the following order. An application Exhibit C prepared by appellant Rahul Gandhi under Section 389 of the Code of Procedure for staying the conviction imposed by the judgment and order dated by the Lieutenant Chief Justice Surat in the so and so hereby is pronounced in the report on this. Robin P. Mugera this. So ये है जजमेंट। अब क्या होगा? राहुल गांधी साहब की एमपी सीट अब वापस मिलने वाली नहीं है और अब अगर इलेक्शन कमीशन को चाहिए, जैसे कि उन्होंने आजम खान के केस में रामपुर में किया था, पहले ट्रायल कोर्ट ने आजम खान को कन्विक्ट किया, सेशन कोर्ट ने कन्विक्शन स्टे नहीं किया और उसके बाद में वहां पर इलेक्शन करवाया, तो उसी तरीके से अब इलेक्शन कमीशन वायनाड में दूसरी बाई इलेक्शन करवा सकता है। रही बात राहुल गांधी की, अब राहुल गांधी साहब, मुझे तो ऐसा लगता है, पता नहीं हाई कोर्ट क्या करता है, हाई कोर्ट में जाएंगे अपील करने के लिए, लेकिन अगर दो कोर्ट से उनके फेवर में जजमेंट नहीं आया है, ऑर्डर नहीं आया है, तो मुझे तो नहीं लगता कि हाई कोर्ट भी उनके खिलाफ कुछ करेगा। तो यानी अब मोतीलाल नेहरू, जवाहरलाल नेहरू, इंदिरा गांधी, राहुल गांधी, राजीव गांधी, सोनिया गांधी और अब ये पांचवी पीढ़ी है, इनकी राजनीति अब यहाँ पर खत्म हो रही है। इस बीच कांग्रेसी एज यूजुअल एलिगेशन लगा रहे हैं कि जो जज था वो अमित शाह से रिलेटेड था, अमित शाह के केस में अपियर हुआ था। ऑल बुलशिट, जो कांग्रेसियों की आदत है, वो कभी भी किसी बात को लीगल उसमें नहीं करते। वो सोचते हैं कि ये परिवार जो है वो अलग ही तरीके से ट्रीटमेंट होना चाहिए उसका, और वो यही चाहते हैं कि ये होता रहे। जैसे कि मैं आपको इनके बारे में थोड़ा सा ट्वीट बता देता हूँ कि ये क्या बोल रहे हैं, क्या क्या कर रहे हैं। ये कल दिल्ली में कहीं घूम रहा था ये हीरो। यहाँ से शुरू करते हैं। ये एज यूजुअल भाई साहब क्या बोल रहे हैं, देखो। बीजेपी कर्नाटका क्या बोल रही है। सूरत के refuses to stay Rahul Gandhi conviction in this foreign puppet Rahul Gandhi is officially convicted in this. फिर बीजेपी today verdict state well that Rajiv Gandhi and his detectives could make judiciary buckle under pressure. Breaking: Surat Court refuses to stay Rahul Gandhi conviction, says he is not been able to show exceptional circumstances to grant stay. Note: this is only second time since 19 that someone has been given 2 years for criminal defamation. इसको बड़ी तकलीफ होती है। एनीवे, मैंने ये वीडियो आपको बनाया था और पूरा जजमेंट ऑलमोस्ट पढ़ के सुना दिया है। ये जजमेंट, अगर ये वीडियो आपको अच्छा लगता है, जजमेंट से अगर आपको कुछ फायदा होता है, तो आप मेरे वीडियो को लाइक करें, अपने दोस्तों यारों के साथ सोशल मीडिया में शेयर करें, मेरे चैनल को सब्सक्राइब करें और मुझे बेल आइकन दबा दें, जिससे आपको नया वीडियो जब भी आता है उसको सूचना पहले मिल जाए। जय हिंद, वंदे मातरम, भारत माता की जय। मिलते हैं अगले वीडियो में किसी और चीज के साथ।